SJC-13878, Luis Contento Suquilanda versus Skyway Roofing, Inc.
Okay, Attorney Bond.
Good morning, everyone. I'm Tom Bond for plaintiff appellant Luis Suquilanda. This case is about a professional roofing contractor who used they're a roofing safety fabricator. They used their expert credentials to get a high-risk commercial roofing job. They agreed with the owner of the project for project safety. They went into the town hall and they swore that they were in control of the construction, and then they pulled a bait and switch. They farmed this job out to a subcontractor they'd used 1,000 times in the 10 years before this happened, and one that they knew had prior OSHA fall protection citations. And they said, I asked James Shanley, the president of the Skyways, I said, were you concerned about that? He said, very concerned. I said, what did you do? He said, well, we monitored them.
I ask you to address the negligent hire argument and square that with workers' compensation in light of the indemnity provision that the general contractor has with the sub.
Yes, Your Honor. This court said in Wentworth that it's very important for general contractors to hire safe, responsible subcontractors, all right? The indemnity provision, with my brother's and my opponent's argument that they'll pay twice, that indemnity provision, that's a matter of contract between the two business entities. It's what it is. The important thing that the court has to understand is that this is a safety situation. People are getting hurt, Your Honor. This is about the integrity of the building permit.
No, I mean, as I understand the restatement provision allowing claims by third parties against the general contractor where the subcontractor harms them, it's about third parties, not employees of the subcontractor. And the question before us is, should it be? Should we allow employees of the subcontractor? And my question to you was, in light of the whole workers' compensation scheme, if we do that, isn't that a potential problem with the legislatively enacted way of dealing with people who get harmed on the job, right? Because your client, as I understand it, received workers' compensation. Is that right?
He did.
So now, in this particular case, what would happen if we allow the negligent hire claim would be, your client would be perhaps entitled to damages from the general contractor.
Exactly.
And then the general contractor would get indemnified, if they could prove it, by your client's employer, right?
Yes, Your Honor.
Right? And so your client's employer would be on the hook for paying the damages to its own employee, effectively, right? And the whole purpose of the workers' compensation scheme is to stop that, right? To sort of have, here's an insurance bucket for all harms that happen on the job, and as a result of that, the individual worker doesn't have a claim against your employer. Instead, you seek funding through the Workers' Compensation Fund.
It has a claim, Your Honor, under Chapter 152, Section 15 deals with this, which says that the first money that you recover is for the benefit of the workers' compensation insurer. So there is no double recovery here, Your Honor. This would stop the practice, which is, I call it the swear, switch, and ghost practice, which is a blueprint for bad behavior by contractors in the Commonwealth. They go into the building department. They swear that they're responsible for construction means and methods. They secretly switch it off to somebody who's not skilled, not licensed, and then they ghost the project.
That's allowed under Corsetti-Stone, though, right?
Under Corsetti-Stone, the issue, Your Honor, if it retains control. You could switch to a...
Right, but you could hire it and not have control and not be liable.
You can. The issue is whether you retain control, not whether you exercise control, Your Honor.
Are you saying...
is when they ghost the site...
I'm sorry.
I'm sorry, Your Honor.
I didn't want you to...
No,
I would like you to finish your answer to Justice Gaziano.
If you could finish, please.
I'm sorry.
You're saying when you ghost the site,
When you ghost the site, okay, and then you put your head in the sand and you say, I didn't control anything here, I'm not responsible, I didn't see anything, I didn't say anything about safety, I didn't hear anything.
But hold it, but if you did what you said, which is made representations that you're going to monitor the safety, that you're going to stay fully on top of the safety to get the contract, then you fall within Corsetti because you've retained control. But that's not what happened here. Here you have the opposite, which is there's minimal, basically there's none of that. So I'm just not sure where, and the other thing you're describing seems to me something the workers' compensation system does, which is these are really your employees, you're leasing out employees, but that's not what's going on here. They're contracting with a real company.
Well,
And the real company is paying workers' comp.
a real company, Your Honor, a company that is a frequent offender, a frequent violator. And this happens all the time, that the general contractors, it's a race to the bottom. They go with the lowest possible bidder that has workers' compensation insurance.
But I don't know, that's apocryphal, I understand, but a record's not going to reflect this, that this is what goes on in society. It may be true, but a record's not going to have that.
7,000 fall protection citations in 2004, according to OSHA. 2.7 times,
7,000 for this particular subcontractor?
not with this
So
subcontractor.
this particular subcontractor, is it one OSHA violation? What's the number on this particular subcontractor?
This, the quote from James Shanley, I said to him, President Shanley, I said, would it concern you that there had been 5 OSHA fall protection citations? He said, oh yeah, we were very concerned. He said,
Concerned with any OSHA violation, but I just don't, and OSHA violations can be serious, they can be minor, they can be, they can be all kinds of things. And this company used this sub thousands of times, I assume successfully. So I'm just not sure where you're going with this.
and he said, Your Honor, he said, I knew they had a problem tying off, So we monitored them closely. He said he monitored them closely, but he never told the on-site supervisor that they had a
He
problem
told
tying
who
off.
that he monitored them closely?
I'm sorry?
Sorry, I apologize. He told who that he monitored them closely? See, because Corsetti creates a possible independent tort when you retain supervision over safety. Makes sense to me. But you're trying to create this new tort, this negligent hiring tort. And it's not even hiring. It's really negligent contracting tort, which I've never heard of before, but it may exist. But it just seems like it's going to open up a huge set of problems.
What it's going to do, Your Honor, is it's going to put a safety incentive for a general contractor to vet a subcontractor before he hires him. And all he has to do is go to the OSHA site, enter the person's name, take his index finger and press enter, and all the citations will come up, all right? And plan the job, the safety, supervise and enforce the safety on the job. That's what we're asking them to do. People are getting hurt.
I don't know, but you're asking us to do something that minimally exists out there for good reason, because it sounds like it's going to reshape the entire workers' compensation system. And I understand your point that, you'll subtract the recovery, but it just seems like there's a whole can of worms here you're opening.
This is again, this is a race to the bottom. It's going to ensure safety. Imagine if this court affirms this case and stamps its seal on this blueprint for bad behavior. What if an electrician?
As far as I know, they've hired a contractor who had some OSHA violation. I don't know how much, but he had an OSHA violation. This is a contractor that's worked 1,000 jobs for them, and someone fell horribly, and that person's got workers' comp coverage, it's got workers' comp health and money. And if they retained a safety function, there would be this separate suit under Corsetti. But you're asking a whole nother world where, you know, and it just seems standardless.
Or maybe you're not. So what I'm confused about is, are you asking us to expand Corsetti? And if not, can you point us in the record, what day-to-day activities did the general contractor retain vis-a-vis the safety requirements of the subcontractor on the job? Because if it's that, you've got Corsetti, right? But if it's not, you're asking us to expand Corsetti to something that we haven't said before. And it's not to say that perhaps there might not be circumstances where we do that. It's just to say, which avenue are you in?
We're asking the court to determine that when you swear to the town official under the building code that you're going to retain control of construction means and methods, that is retained control under Corsetti.
That's what I wanted to ask you about. Can you give me your record site for where that swearing took place? Is it in the building permit application? When you say they swore to retain construction control?
Your Honor, the building permit documents are in the record.
All right, so I don't see this statement as to retaining control over construction methods. That's what I'd like to ask you to point me out to specifically.
Your Honor, the permit designation, the application is at Appendix 257.
I'm looking at it right now on my screen.
259.
Yeah,
But
so where is it? Can you tell me in there? Because I see a Section 10 that asks for construction control. It has to be filled out. A person's name in there is registered professional responsible for construction control, but that's not the defendant here. That's some other person or entity.
Your Honor, that's the supervisor for Skyways. That's Christopher Burrows.
That name is under general contractor. I'm looking at 258, Record Appendix, page 258. Maybe you can help me. It looks like there's a Vincent Guntho.
He was the architect, Your Honor, just to make sure
Right.
that.
So that is what they answer in terms of question 10. And then, or maybe general contractor, are you saying that just by saying that they're general contractor, then they've retained, that's enough to go towards satisfying the Corsetti test?
Yes, Your Honor. Under the building code itself, 107.6.3, when you swear to the town official under oath that you are the project manager, the general contractor, and the person responsible for construction, and Skyway lists itself as the employer on the project. Nowhere in any of that does it mention MBT.
So then,
Sure, but it doesn't ask for any subcontractors. And is there a requirement? Well, first of all, once a general contractor fills out the permit, the building permit application, are you saying that they are precluded from hiring subcontractors?
No, I'm not saying.
Okay, so are you saying that they are required to disclose that they are going to hire subcontractors?
No.
Okay, then where are we then in terms of saying that they said something in this document that bears on the Corsetti
They
test?
are responsible for construction means and methods, Your Honor.
Okay.
They retain control. It's a representation to everyone that they're retaining the safety control on this project.
doesn't that mean that every worker's compensation, every time a worker is injured in the construction industry, there's going to be two separate claims. There's going to be the claim against the employer and the claim against the GC.
No, Your Honor, because
Because you just said they are filling out the form, and the GCs are going to fill out the forms.
that doesn't mean, Your Honor, that they are vicariously liable for the subcontractor's negligence. For example, if they're swinging a hammer and they
You're
hit
saying they're directly liable because they've sworn to, on construction, what is the word used, means and methods or whatever. That's transforming the world we have out there for injuries and construction.
Maybe not. What you said before, though, is that you seem to try to have guardrails here that could be the safety net, that the general contractor, in this case you're alleging, knew about the issues with this subcontractor, and maybe that would be the limiting principle, that it's not just saying just because you pulled a permit on it, you pulled a permit and you hired a subcontractor that you knew you should not have because they're, and so that it's not saying that everybody wins, it's saying that we now have a cause of action and you've got to go out and prove it.
Exactly, and that's what the Alaska Supreme Court said in Severs. And this court said in Wentworth that it's important for general contractors to hire responsible subcontractors. If you know, and the record is clear, they knew.
Wentworth is the case where the subcontractor had no workers' compensation insurance, right?
That's exactly it.
So that's a whole different ballgame. That means that poor employee had no workers' comp, had to sue, and had to sue the GC. That's a different situation than this. And again, the exclusivity provision in workers' comp has a purpose. And you're really trying to get into the opposite of supervision, which is the absence of supervision. So you're going to have it on both ends now. You're going to have Corsetti where they retain supervision, and your negligent hire where they don't retain supervision. That just sounds like that's a legislative change in the way the workers' comp laws work.
Part of what Corsetti requires, Your Honor, is for them to retain control. We've got 4 instances of retained control here. We've got the contract with the owner where they agree that they're going to do the job safely. Now, my opponent says, well, do the job safely, it means to keep the shrubberies safe. No, it doesn't. Not in this context, with all inferences construed in favor of the injured worker. It means that they're going to maintain safety on the job. We've got the fact that these people aren't entirely free to do the job their own way. They were monitored for a while, so they showed that they had the authority to monitor the workplace.
Every GC monitors a construction project in a global sense. They don't, that doesn't mean they get up onto the roof and see whether the guys are attaching the ropes properly, because again, they're relying on the sub to do that, unless they've assumed responsibility in the documents, like in the Suffolk construction case.
They did assume responsibility, Your Honor, in the contract and by their actions on the job. They provided a skylift, they provided equipment, they provided monitoring of the fall protection. They weren't entirely free to do it their own way.
If we were to recognize this new tort, how would you define the scope of the duty?
A general contractor that swears under the building permit has a responsibility for job site safety. He must plan the safety ahead of time, vet the contractor, vet the subcontractor, and make sure that subcontractor is safe. Supervise the person, doesn't mean you have to babysit, and then enforce if they see anything, you know? So it doesn't mean vicarious liability. Their responsibility starts, Your Honor, when, at the time that they hire the subcontractor, before the work even begins. That's where the negligence is. Negligent hiring has been in this Commonwealth for decades. That's not a new tort.
It's negligent hiring of your own employees. It's never been extended to you negligently hired a contractor and their employees got hurt. This is a first for that.
It is a first. If this is not allowed, Your Honor, what about if an electrician, and incidentally, this is not a general contractor that is a manager of expert trades. This is a general contractor who, it's a specialized contractor whose only job is roofing. Now, suppose an electrician pulls a permit and decides, you know what, I don't want to pay my guys $40 an hour to do this. I'm going to hire a cheap, unskilled, untrained team to do the electrical work. That's a fire hazard for everybody in this court. Suppose
Those are the third parties.
I'm sorry?
That's different, right? If I'm a general contractor, electrician, and I hire bad electricians, and then the court gets hurt, That's different than what you're talking about.
Okay,
You're talking about one of the bad electricians, he gets hurt. And so the question before us is a little different than what you're positing here.
the workers that are on the job, they don't have, these aren't union workers for the most part that I represent. These are people who, they're black and brown people who, some of them don't have immigration status. If they protest about the work, and there's an argument that, well, you know, they're in the best position to identify unsafe work, really? You know, the ICE is going to be called on them. The person in the best position to identify this is a roofing safety product manufacturer and a company that's been in business since 1992, doing roofing, just roofing contractor work. And I asked him, I said, why do you use this captive subcontractor? And he said,
Can I ask you just
economic
to
reasons.
address the causation problem, because I know you're over time.
Oh, okay, I didn't even notice that. Yeah, the causation problem is, that's a comparative negligence issue, Your Honor. That's a jury question.
All right. Thank you.
Thank you very much.
Okay, Attorney Hansford.
Chief Justice and Associate Justices, may it please the court, Masha Hansford of Paul Weiss for Appalachia Skyway Roofing. The court should affirm the judgment of the Superior Court. First, this court should not recognize the new type of negligent hiring claim that Mr. Contento seeks to assert. Second and separately, there's not evidence in this record to support a negligent supervision claim under Corsetti. The most important question before the court today is that first question. This court should not, for the first time, recognize a negligent hiring claim by the employee of a subcontractor against the general contractor that is premised on the theory that the general contractor was negligent in hiring the employee's own boss. The vast majority of courts in other jurisdictions, as Justice Kafka indicated, who have considered this type of claim have rejected it, and that is with very good reason. The claim is very flawed as a conceptual matter and as—
Why do you say that? Because as a conceptual and a practical matter, it would seem to make sense. So you've got a GC, your GC's bidding a job, and in order to make his margins work, he's going to take the lowest subcontractor he can find. And whether or not anybody wants to admit it, we know what's going on. You're going to go with the guy who's going to cut the most corners so that his margins could make sense to bid the job at that cost. So of the people that subcontractor is going to hire, they are the people who are never going to come in and say, hey, boss, I think that, you know, you're cutting corners here because you want to make a few more bucks, and it's really me that's got my neck on the line. Why wouldn't it make sense in this context with the realities of what we're actually trying to do under the workers' compensation structure, and that's to protect workers?
Justice Georges, I think that's precisely why we have a workers' compensation scheme. So I absolutely take the point that these employees are vulnerable, and that is precisely what the workers' compensation scheme strives to address. And under that scheme, there is a requirement that the subcontractor carry insurance. And a subcontractor that is the worst subcontractor, the sloppiest, the most dangerous subcontractor, is actually going to have higher insurance premiums. And so kind of one of the insights of the workers' compensation scheme is it actually internalizes that risk and makes it desirable to hire good subcontractors because they're going to have lower workers' compensation premiums.
Good subcontractors do good work. And, you know, you want good work done in your building as well as not cheap work, right?
Absolutely, Justice Kafka. Skyway Roofing has its reputation. It wants to hire, if it's going to hire subcontractors that are going to cause accidents, nobody's going to hire Skyway Roofing. It's putting its own reputation on the line as well. And so I think that some of these vulnerabilities and some of these concerns, which I appreciate are important, are the precise ones the legislature took into account. And while we're on the topic of the workers' compensation scheme, I do want to walk through the kind of—
Before you leave there, though, I do have to challenge you on that, because if you can't sue your client, your client's potential clients will never know that Skyway's hiring folks that aren't doing the job the way they should do it.
I don't think so, Justice Georges. Jiminy Peak knows that there was this accident on its property. You know, I presume they're not happy about this. This is not a situation Skyway, Jiminy Peak, other customers want to be in. It's not a secret, and that is true even setting aside the negligent hiring claim, because there was an alleged Corsetti claim as well in this case. But even aside from any lawsuit, everybody knew the accident took place. OSHA noted it. It's public information that an accident took place. So I don't think litigation is the only way to get at that. And I think that the problems with the workers' compensation scheme are actually more profound, just in that this is not necessary.
Before you do all that, could you go to the opinion Justice Wolohojian wrote on the appeals court? Because that gets into the subtleties of how Corsetti works. So, and one question I have is, it's not that high a standard for getting yourself on the hook, meaning if you retain some safety responsibility, you can be sued. So will you address that? Because it doesn't seem to, it's not such a high standard to meet, right?
And Justice Kafker, just to be clear, you're asking about the separate Corsetti claim, not whether you should create negligent hiring, but why we should win on the Corsetti claim as the Superior Court ruled. Sure, and I'm happy to address that.
Before we go to the moon, let's try to start on this planet.
Very happy to start on planet Earth. Okay. So I think these court's cases lay out a very clear line about when a Corsetti duty, which is a narrow exception to the general rule that you can contract work and subcontract work out and not be liable for physical injury that results. The Corsetti duty, I think the through line through this court's cases is that there's a specific duty retained as to the safety of the subcontractor's employees. And so I can tick through the key language in the cases on both sides of that set out that line. So in Corsetti, the language was that the general contractor specifically contractually retained all reasonable precautions for the safety of all employees and to provide all reasonable protection for the employees, specific duty as to the subcontractor's employees. The De La Veria's case, also the general contractor contractually provided that they would be, quote, solely responsible to take all proper precautions to protect persons from injury. The Kostriva case, which is an intermediate court of appeals case, there was responsibility for all safety precautions and to prevent damage, injury, or loss to employees. That's on one side. On the other side, of course, is this court's decision in Lyon. And there was actually a very similar case, a roofing case, and the hospital that hired the roofer had removed safety railings. And there was a Corsetti duty alleged in that case because the hospital retained responsibility for general safety and had the power to stop work if the safety did not meet expectations. And this court said that was not enough. That was not a specific enough retention of duty. And here we are completely in Lyon territory, not in the Kostriva Corsetti type territory. There's no specific language. And not only is there no specific language in the contracts retaining authority over the safety of the employees, there is, as several of you alluded to during my friend's argument, a course of performance of many, many years. And throughout that course of performance, MBT was responsible for all the training of the employees, all the fall protection. That had always been MBT's responsibility. This was not a situation where Skyway reached out and took on this responsibility in a way that would create a Corsetti duty.
Let me read you one sentence from the appeals court decision, which quotes De La Veris, whatever. It should not be determined on summary judgment whether a general contractor has sufficient control to be liable to a subcontractor's employee is a question of fact for the jury. It should not be determined on summary judgment unless viewing the evidence in the light most favorable to the plaintiff, the undisputed material facts demonstrate as a matter of law that the defendant did not exercise any, here's the key language, meaningful control, however minimal, over the subcontractor.
Yes, that's correct. But the key thing is it's meaningful control as to the safety of the employees. And control means more than the general stop work order. That's the Lyon decision. That's restatement 414 comment C. It's actually specific control over the safety. And there's no evidence in the record there. If Skyway wanted to go to MBT and say, change how you're doing this, and MBT said no, Skyway would have had absolutely no power to do anything other than the general stop work order. That's not enough. And I think think that's precisely why Corsetti is a limited exception that does not create a claim in every single case.
I just want to raise something that Justice George has been pushing at. Does this create a weird incentive, though, that if the employer is trying to be careful and retaining control, he gets in trouble or she gets in trouble, but if they're hands off, they don't?
Mrs. Kafka, I think that's a very important point, and that's why it's very important to keep the Corsetti duty narrow. If the Corsetti duty became more amorphous, and that any time the general contractor was a good citizen and said, whoa, you're doing something that doesn't look safe, change it. If that created a Corsetti duty, general contractors would not do that, and that extra layer of protection for employees would be removed. But this court's cases have been very disciplined in requiring a very specific duty, and I think that avoids this kind of incentive.
Can I ask Justice Kafker's question in a more pointed way? So I think what Justice Kafker was saying was that there is actually, as a result of the Corsetti line of cases, however broadly or narrowly you construe them, an incentive not to retain control over safety, because then you will not be liable on a control basis, correct? You're nodding. There's an incentive not to retain control if you do not want to be liable for accidents. And so therefore, the players higher up the chain, the general contractors and so on, they have an incentive. The people with potentially more specialized knowledge, people with higher up the chain have an incentive not to retain control over safety and thereby subject themselves to liability. Your position in this case is that holds true no matter how negligent they are in hiring their subs with respect to their subs' safety vis-a-vis employees. And even if a GC knows that the sub has multiple employees of the sub have been killed, they can still just hire that sub, and as long as the contract is like, it's all on you, they can never be liable for not acting in a reasonable manner vis-a-vis hiring a sub known to have repeated worker deaths. Can you address that incentive, that sort of incentive situation, which I think is what Justice Kafka was getting at?
Yes, and I want to address that kind of egregious hypothetical. I think that as a practical matter, that would not arise because a sub that has had multiple employee deaths would not be able to get workers' compensation insurance and would not be able to be employed for that. And there are also the reputational concerns we discussed. But I think that a key reason that you don't want a negligent hiring claim is not just that it's superfluous, is that it's actually counterproductive to the workers' compensation scheme, because the workers' compensation scheme is trying to eliminate litigation over these cases. And
the workers' compensation scheme explicitly says that you can sue non-employer defendants and make workers whole. The workers' compensation scheme isn't against workers being made whole for their injuries.
It's not against workers being made whole, but what you're going to have is you're going to open up a can of worms in terms of litigation. You're going to have not only there's a subrogation claim that goes to the insurer first. So instead of the workers' compensation insurer that actually contracted for this particular case, the first person who's going to get reimbursement is not Mr. Contento here. It's that workers' compensation insurer. And then there's also the indemnity provision that Justice Wendland was discussing. And so the risk has shifted from the person who's supposed to be monitoring the risk, that insurer, to the general contractor. And then it's going to go from the general contractor back to the subcontractor, and is going to depend on the randomness of, is the contractor judgment proof or not outside the context of the workers' compensation insurance. And so you're going to have all this litigation. At the end, Mr. Contento might not have any more compensation. And if he does, there's a randomness to that. Because of course, if there was no subcontractor,
all of that sounds like policy reasons. I'd like to just focus on, I think, what we're talking about, and that's the cause of action. The cause of action isn't strict liability. The cause of action is you get to plead it, and if you prove it, maybe you can get damages, and if you don't, maybe you get bounced on summary judgment like you have here. So focusing on the claim, I just don't understand the argument for why should Massachusetts categorically just reject liability when like we do in all other negligence contexts, when the plaintiff's harm is foreseeable?
So I think think about the scenario where there was no subcontractor at all. If Skyway had hired Mr. Contento, had negligently trained him, the only thing Mr. Contento would receive is workers' compensation insurance. The Massachusetts legislature struck the balance at the appropriate level for that, and it's somewhat of a windfall. And I would point you to Justice Abrams' opinion in Vertantes, the concurring opinion that kind of explains the reasons that it's very odd to create this kind of duty to the employee of the subcontractor. And it explains that the reason that Section 15, which Justice Dewar you were alluding to, allows these other claims is sometimes there's a third-party wrongdoer, and we don't want the wrongdoer to be off the hook.
The Vertens case was unlike this, was a vicarious liability case, and the court was very clear that they were not talking about a negligent wrongdoer.
Yes, absolutely, and we don't think it's binding, but I think a lot of the other jurisdictions started with a case like Vertantes and reasoned from that to this type of situation, and that's because a negligent hiring claim, unlike the Corsetti type of claim, is trying to hold the general contractor liable based on the negligence of the subcontractor and saying you are negligent in hiring this person because they're a negligent contractor. And the effect of that, and maybe this will get to your concern, Justice Georges,
it's not saying that. It's saying we're going to make this like all of the other negligent hiring cases that we have. So you've got to adduce facts to show that you knew or should have known that you were hiring this negligent subcontractor.
Sure, and we can talk about what those facts would be, because I think the OSHA kinds of violations are a really bad sort of fact, but I think that because the negligence is based, and the Restatement 3rd, Section 55 makes this point that that's kind of the core of the negligent hiring claim, and why that one is a particularly troubling type of claim to imply, is that then you would just have Skyway not hire a subcontractor at all. And we heard a lot about how subcontractors are bad, but they provide specialized expertise in this kind of work. Here, that expertise was sloped roof work as opposed to the flat roof work that Skyway did. And I think the common law recognizes the benefits of contracting and doesn't just try to incentivize against it. But I think that would be the effect of it. If Skyway were on the hook through negligent hiring as a backdoor for all the negligence that MBT had, they would just have an incentive not to subcontract out. That would make Mr. Contento no better off. And in fact, it would take off a layer of review. And if I can just get...
He's not going to be any worse off because somebody has to have workers' comp. So, I mean, he's getting his health care and he's getting his salary, I mean, whatever his payments, because he's getting workers' comp. That's what makes this a little harder, because we're not in this sort of pure tort world where he's not got workers' comp. He's got workers' comp recovery.
I think he would just be worse off in the very small respect that here there was that second set of eyes, and I think the record reflects that Skyway had a salutary role in checking in with MBT after it learned of the OSHA violations and saying, hey, we want to make sure you're doing things a safe way. I think that extra layer actually benefits as opposed to harms workers, but that's a pretty small point. If I could just address the OSHA point, and I wanted to talk about the permit and the delegation point as well very briefly. I realize I'm out of time, but on the OSHA point, the Massachusetts legislature and the Congress have not made a decision that somebody who has an OSHA violation thereafter cannot work. In fact, the violations only have a cap of about $16,000 each. And so I think that the idea that it's automatically negligent to hire anyone who has an OSHA violation,
I don't think anyone said that. It's just evidence. It may just be evidence of the foreseeability. That's all.
No, I think it's fair that if you recognize this claim, it would be evidence, Justice Georges, but it's very hard to frame a rule that is not going to just mean in every single case where there's negligence by a subcontractor is going to be brought and get past summary judgment on a negligent hiring claim. And I think that would really undo the workers' compensation regime by creating this litigation and all this moving around and the moving around of risk from the party that is best suited to monitor it.
So if we were to recognize this new tort, how would you define the duty?
So I want to, if you were to recognize this new tort, we would urge you to define the duty narrowly to say only if there were red flags that this contractor was so incredibly negligent, that hiring them was beyond the pale. But as I thought about how to articulate this for you as a fallback position, it's very difficult, as I just mentioned, to articulate any rule that isn't just going to open the door to bringing this suit in every single case. And I think that this should give this court pause. And just to say a word about the the idea that the permit makes them liable. This court has rejected the argument that the permit creates a non-delegable duty in the St. Germain decision. And after that decision, the Massachusetts legislature actually adopted a provision that said everybody who pulls a permit is liable for injury that results due to a violation of the permit, and it repealed it 2 years later. And I do think my friend Mr. Bond's argument is really trying to ask this court through tort law to recreate this kind of failed experiment that the legislature has rejected. And so I don't think that's the current law, and I don't think you should follow that.
Okay. Thank you very much.
Thank you.